DC's U.S. attorney declined to prosecute more than half of felony arrests made by DC police last year.
WUSA 9 investigative reporter Nathan Baca sat down with the U.S. attorney Matthew Graves to ask him why.
DC's U.S. Attorney Matthew Graves meets community members and fellow law enforcement at Northeast's Rosedale Recreation Center. It was for National Night Out, and though his speech was not listened to by many,
there will be bumps along the way.
Graves's decisions on who gets prosecuted from DC police arrests are among the most important and misunderstood factors affecting DC crime.
One thing that your viewers may not be aware of is that the law has actually changed a lot in the district over the last few years in this area.
How so?
Our highest court in DC, the DC Court of Appeals, which is responsible for interpreting the Constitution, has issued a series of opinions over the last decade and the last 5 years in particular that have pretty much dramatically changed what officers can and can't do when it comes to conducting protective pat-downs of individuals that they suspect might have illegal firearms.
There were two landmark cases that prosecutors lost here at the DC Court of Appeals on Judiciary Square. To describe what happened, we're taking you to the DC neighborhoods where the arrests happened. In the case TW versus US, DC police officers spotted a man they say was acting suspicious in the southeast alley. They pulled their cart alongside him, got out on both sides, and asked the man, "Do you have a gun?" The man said, "No." DC police officers asked, "Are you sure?" And the man replied, "Yeah, I'm positive." An officer asked, "I can pat you down just to make sure?" The man said, "Yeah." Officers found a handgun with a high-capacity magazine. But the DC Court of Appeals overturned that conviction, deciding the man did not know he had a right to say no to that search. In the case Mayo versus US, a 19-year-old man was, in the court's words, just hanging out with friends in this Kenilworth alleyway. Now, DC police officers said they spotted the man making slight adjustments to his waistband, so police officers got out of the car and asked the man, "Do you have a gun?" The man started to run, so officers began chasing him. They did a diving tackle, actually tripping him up. They found drugs and a gun minutes later, and they actually ended up having a DNA and fingerprint match to the man who they arrested just minutes later. But the DC Court of Appeals overturned that conviction because they said that officers had no probable cause for that diving tackle.
From 2018 to 2022, we lost 75% of the cases where the DC Court of Appeals was analyzing these issues of patting down individuals.
Why do you think that's so? What's your professional opinion about that?
So I think the judges are interpreting the Constitution as they see it.
Because DC is not a state, its Court of Appeals has judges appointed by both Republican and Democratic presidents for lifetime appointments. If it was a state, either a governor or the voters would select the judges making these Fourth Amendment decisions.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures.
The American Civil Liberties Union agrees with the appointed DC Court of Appeals' recent decisions.
That they're not going to be influenced by this or that crime statistic. They are looking at the rights of the individual as they should be.
Nathan Baca, WUSA 9.